Very good morning, all the participants who are watching this video. We had very recently published a lot of video lectures on Companies Act 2016 in 4 sessions. Now we'll try to cover this Insolvency Act of 1967. This is intended to be a brief overview and interpretation of the scope, definitions, and key concepts that underpin the entire Act. Now, first of all, let us understand the scope and application of the Act. So it applies throughout Malaysia, Peninsular, Sabah, and Sarawak. It governs insolvency and bankruptcy of individuals and firms. It does not apply to corporations or companies, which are governed by Companies Act, on which we have already released 4 video lectures. And High Court has exclusive bankruptcy jurisdiction under Section 88. Now let us understand the key definitions which are given in Section 2. Director General of Insolvency is the person who administers estates. Secured creditor is a person who is holding a mortgage, charge, or lien. Social guarantor. Social guarantor is a non-profit guarantor for education, vehicle, or housing loans who has given a guarantee arising out of social obligations and not out of business connections. Nominee is a person who assists debtor in voluntary arrangement. Registrar includes deputy and senior assistant registrar. Besides this, there are some core legal concepts like property. Property includes money, goods, land, obligations held worldwide. Liability may be express or implied obligation to pay. It could be either fixed or unliquidated. Ordinary resolution means majority in value of creditors voting. Special resolution means majority in number and 3/4 or more in value. Remote communication technology is allowed for meetings as per Section 2023 amendment. Now, let us try to understand the voluntary arrangement and bankruptcy proceedings. Section 2A to 5. These are alternatives to bankruptcy and the road to a bankruptcy order. Voluntary arrangement. What is it? Section 2A. So Section 2A says a composition in satisfaction of debts or a scheme of arrangement of a debtor's affairs. So this is the concept of voluntary arrangement. This voluntary arrangement is a pre-bankruptcy mechanism and it is available only before adjudication of bankruptcy. It is not available to undischarged bankrupts or limited liability partnerships. It was introduced by the Bankruptcy Amendment Act 2017 and is considered to be a major reform. This voluntary arrangement is overseen by a registered nominee and supervised by the Director General of Insolvency. Approved arrangement binds all creditors who received notice as per Section 2K. So Section 2G says that the debtor appoints nominee. So nominee must be registered with Director General of Insolvency and consent is required from majority partners in case of a firm. Second in line is to apply for the interim order. This is filed in court and copy of the same is sent to Director General of Insolvency. It protects the debtor from bankruptcy petitions while order is in force. Nominee's report. Nominee prepares proposal document and summons meeting of creditors. Creditors meeting. Creditors vote on debtor's proposal. Ordinary or special resolution is required. Report to court. Nominee reports result to court within 4 days and court is notified of the outcome. And then implementation starts. So approved arrangement supervised by nominee, and Director General of Insolvency may intervene in case of non-compliances. So these are some of the key aspects of voluntary arrangement, which are contained in section 2C to 2N. Now section 3. What is an act of bankruptcy? Any of these acts by a debtor enables a creditor to petition for bankruptcy. If there is a fraudulent conveyance, gift or transfer of property, if there is a fraudulent preference of a creditor, if there is departure from Malaysia with intent to defeat the creditors, filing a declaration of inability to pay the debts, statement of affairs, execution against debtor's property returned unsatisfied, notice of suspension of payment to creditors, and petition must be filed within 3 months of the act of bankruptcy. So the law of limitation applies. Now creditor's petition. What are the conditions which are given in section 5? So debt must be 1 lakh ringgits or more raised from 50,000 ringgits by Insolvency Amendment Act of 2020. Debt must be liquidated sum payable either immediately or at a certain future time. Act of bankruptcy must have occurred within 6 months preceding the petition. Creditor must have provided 7 days of intent by way of a demand. Special protection for social guarantors is there. So creditor must first exhaust remedies against the principal debtor in case he wants to proceed against the social guarantor. And court may dismiss the petition if the debtor can show a valid counterclaim or dispute. Debtor's petition and effect of bankruptcy order. Debtor's petition, the provisions are given in section 7, which say that debtor may present own petition if he is unable to pay the debts, must submit a full statement of affairs with the petition, court issues bankruptcy order if satisfied of the inability to pay, Director General of Insolvency takes over administration immediately upon order, and no minimum debt threshold is there, so debtor can self-petition at any amount. The effect of the bankruptcy order is given in section 8, which says that order relates back to the act of bankruptcy. Section 47, relation back doctrine. All property of the bankrupt vests in Director General of Insolvency. Creditors lose individual right to sue or enforce because Director General of Insolvency takes over. DGI immediately takes possession of books, accounts and documents. Bankrupt must cooperate fully with Director General of Insolvency on discovery of property. Now let us have a look at the disqualification and disabilities of the bankrupt, which are given in section 36 to 39, legal consequences of being adjudged bankrupt. So a bankrupt cannot be elected or sit as a member of parliament or state legislative assembly, cannot hold public office or act as a magistrate, justice of peace, automatically vacates any public office held at the time of bankruptcy order, cannot act as a director, manager or promoter of a company, right? In this regard, we can see also the Companies Act 2016, which imposes similar restrictions. Cannot practice as an advocate and solicitor, auditor or accountant, cannot act as executor or administrator of an estate, cannot vote in elections while undischarged in certain circumstances. So these are the disqualifications of a bankrupt. Now let us see the duties and disabilities of an undischarged bankrupt, which are given in section 38. What it says. So this undischarged bankrupt must not obtain credit exceeding 1,000 ringgits without disclosing bankruptcy status, must not engage in any trade or business under a different name without disclosure, must not leave Malaysia without written permission of Director General of Insolvency, section 38A. Director General of Insolvency may surrender the bankrupt's passport to prevent departure. Must attend all meetings of creditors whenever required, must provide full disclosure of property, debts and transactions, must execute all instruments and do all acts directed by Director General of Insolvency, and list of undischarged bankrupts maintained and made accessible by virtue of Section 39. Now let us understand the process of administration of property, which are contained in sections 40 to 69, how a bankrupt estate is managed, proved, and distributed. Proof of debt, section 40 to 46. So all debts and liabilities, whether present or future, certain or contingent, are provable. Mutual credit and set-off is allowed, and only the net balance can be claimed. Secured creditors may realize their security and prove for the balance, and the priority of unsecured debts under section 43 is as under. First of all, costs of bankruptcy proceedings are paid. Second, wages of employees, but there are certain capping, like in Companies Act also, similar capping is there. Third, tax liabilities, and fourth, ordinary unsecured creditors, which have pari passu charge. Landlord may distrain for up to 6 months arrears of rent. Property available for distribution. Section 48. All property belonging to or vested in the bankrupt at the date of the bankruptcy order is available for distribution. Property which is acquired by the bankrupt before discharge vests automatically in Director General of Insolvency. What is excluded and which is not divisible among creditors? Tools of trade up to prescribed limit, necessary clothing and bedding for bankrupt and family, provident fund and pension monies, EPF, pension under written law, spouse earnings and property acquired after marriage are separate. Section 46. And property held on trust for others does not vest in DGI. Now, avoidance of antecedent transactions, which are given in section 52 to 54. Voluntary settlements are void against Director General of Insolvency if they were made within 2 years of the bankruptcy commencement. Settlements are void for 5 years if debtor was insolvent at that time. Exception is a bona fide purchaser for value without notice. In this case, transaction stands as it is. Fraudulent preferences, which are given in section 53, are transactions favoring one creditor over others, and these are voidable if undertaken within 6 months and at that time the debtor was insolvent. Assignment of book debts is void against Director General of Insolvency unless registered as a bill of sale. Fair market value may be fixed by court for assets transferred at under value. Director General of Insolvency may recover property or its value from recipients in case of void transactions. Now, let us see the powers of the DGI to realize property, which are given in sections 55 to 61. Property seizure and control. So, DGI shall take immediate possession of all bankrupt's property, seize goods, documents, books of account, redirect mail to DGI's office, appropriate portion of pay or salary of bankrupt for creditors, and disclaimer of onerous or unprofitable property. Regarding dealing with assets by DGI, it can sell or mortgage property by public auction or private contract, carry on the debtor's business for benefit of creditors, bring or defend legal proceedings in the name of DGI, exercise powers subject to court orders, and allow the bankrupt to manage property if it is considered beneficial for estate. Now, distribution of property, which is given in sections 62 to 69. So, DGI declares dividends as sufficient funds become available. Notice of intended dividend given to creditors who have not yet proved their debt. Joint and separate dividends in partnership bankruptcies. Final dividend, DGI gives notice before closing the estate. But no legal action can lie against DGI for a dividend. And creditors residing abroad given extra time to prove debts. Any surplus remaining after payment of all debts with interest is returned to the bankrupt by virtue of section 69. Now let us understand the concept of Director General of Insolvency. which is given in section 70 to 87, which contains appointment, duties, powers, and accountability of the DGI. The Director General of Insolvency, role and status, section 70 to 74. Appointed by the Yang D. Patuan Agong, part of the Prime Minister's Department, acts as the official receiver and trustee of all bankrupt estates in Malaysia. Has the status of a body corporate, it can sue and be sued. Primary duties are to administer the bankrupt's estate and investigate conduct. Must report on bankrupt's conduct to the court when discharge is applied for. It is protected from personal liability in case it is acting in good faith. DGI office vacates if he himself becomes bankrupt. Financial controls and accountability given in section 76 to 81. So bankruptcy estate account includes all monies received held in official government account. Insolvency assistance fund. This is established for operational expenses of insolvency administration. Surplus funds shall be invested as directed by the minister. Accounts subject to audit by Auditor General. DGI must keep proper books of account for each estate. Official examination of DGI records may be ordered by court, and DGI must furnish list of creditors whenever required. Now let us try to understand the provisions regarding discharge of bankrupt, which are given in section 33 to 35A. There are three routes to discharge a person from bankruptcy. One is by way of court orders. So bankrupt applies to the court, and court may grant, refuse, or grant with conditions. It can be on an application of the bankrupt or DGI. DGI certificate, section 33A. So DGI issues certificate of discharge. It applies mainly to bankruptcies below a prescribed debt threshold, and creditor can object to such discharge within 21 days. Automatic discharge, section 33C. It is automatic after 3 years from date of bankruptcy order if statement of affairs is filed and bankrupt has complied with all obligations. Now, what are the conditions and effect of discharge? Section 33 to 35A. There are certain conditions and grounds for refusal. So, court may refuse or suspend discharge if bankrupt acted fraudulently or speculatively contracted debts without expectation of payment. If there is a failure to cooperate with DGI, if there is a failure to keep proper books of account before bankruptcy, if he is leaving Malaysia or is absconding, or suspension of automatic discharge if creditor approves misconduct. Now, what is the effect of discharge? It releases bankrupt from all provable debts, does not release from debts incurred by fraud, does not discharge student loans from government. Discharged bankrupt must continue to assist DGI if required, and disqualifications which are contained in section 36 and 37, they are lifted upon discharge, passport is returned, and travel restrictions are lifted. Now, court jurisdiction and procedure contained in sections 88 to 105, powers, procedures, and appeals in bankruptcy proceedings. Court jurisdiction in bankruptcy, section 88 to 91. So, High Court has exclusive jurisdiction in all bankruptcy proceedings. Registrar of High Court exercises jurisdiction in chambers. Court has general power to rescind orders, extend time, and amend proceedings. Appeals from registrar go to a judge in chambers. Appeals from judge go to Court of Appeal and Federal Court. Discretionary powers are there, wherein the court may exercise them on terms and conditions which are given in section 93. And court may consolidate petitions against the same debtor. Now, annulment of bankruptcy order, section 105. So, court may annul the bankruptcy order if the order ought not to have been made, for example, in case of disputed debts. Bankrupt has paid all debts in full, including interest and costs. Creditors have approved a composition or scheme of arrangement or other grounds that the court considers just and equitable. On annulment, property revests in the debtor and the disqualifications are lifted. So DGI may retain fees and costs incurred before annulment, and annulment is distinct from discharge that is extinguished retroactively. Now, partnership bankruptcies and cross-border provisions, which are given in sections 98 to 104. So, court may present petition against one partner in a firm without petitioning against all. Consolidation of joint and separate bankruptcies of partners is possible. Action by DGI in partner bankruptcies may be in the firm name. Reciprocal provisions with Singapore and designated countries. Malaysian bankruptcy orders are recognized in Singapore and vice versa. Property in designated countries may be recovered by DGI, and court may continue proceedings despite death of the debtor. Now let us try to understand the provisions regarding small bankruptcies, which are contained in sections 106 to 108, summary administration for smaller estates. So this summary administration, which is exclusively designed for small bankruptcies, it applies where the bankrupt estates are likely to be under a prescribed amount. It is simpler, faster procedure. So summary administration by DGI without full court proceedings. No public examination of debtor is required in small cases. Wage earner provision and special procedure for bankrupt employees with modest income. Creditors meeting requirements may be simplified or dispensed with. Purposes to reduce cost and delay for straightforward low value estates. So DGI has discretion to administer under summary or full procedure. Now fraudulent debtors and creditors. Section 109 to 119, criminal offences and penalty in insolvency. So section 109, in case of fraudulent debtor, which includes concealing, removing or disposing of property to defraud the creditors. Section 110, failure to keep accounts if he is not maintaining proper books of accounts before the bankruptcy commencement. Section 111, reckless credit, contracting debt without reasonable grounds to expect payment. Section 112, absconding with property, leaving Malaysia, taking property to defraud the creditors. Section 113, if he is absconding, evading service of bankruptcy process. Section 114, fraudulent credit, obtaining credit by false representation of being discharged. Section 115, false claims, filing false proof of debt or making false statement to DGI. Section 116, debts by fraud. So debts not released on discharge if incurred by fraud. Now let us see the supplementary provisions. Section 120 to 139, miscellaneous rules, fees, evidence and transitional matters. Regarding married women, they are treated the same as any other individual debtor. In case of corporations and companies, these are explicitly excluded by virtue of section 121. Insolvent deceased estates, so act applies to administration of estate of person dying insolvent. Power to make rules, minister may make subsidiary legislation by virtue of section 123, and fees is prescribed by the minister via insolvency fees rules, which are given in section 124. Section 125 says that Gazette is primary evidence of all matters published therein. Evidence of creditors meeting proceedings given in section 126. Affidavits sworn before commissioner for oaths are admissible. Section 128. Service of notices, personal, postal or electronic, post 2023. Section 130. Formal defects in proceedings do not invalidate them. Section 131. And stamp duty exemption for documents in bankruptcy proceedings, 132. Now there are certain key subsidiary legislations under Act 360. Insolvency rules. It governs all court procedures in bankruptcy. Insolvency voluntary arrangement rules. Procedure for voluntary arrangements. Insolvency cost rules, which include taxation of costs. Insolvency fees rules. Fees payable to DGI. Insolvency application for registration of nominee. Insolvency amendment rules, electronic service, remote meetings, and all rules made under authority of section 123 of the Act. Now let us see the major legislative changes which took place between 2017 to 2023 and how the Act has evolved to meet modern needs. Bankruptcy Amendment Act 2017. What were the key changes? So Act renamed from Bankruptcy Act to Insolvency Act 1967. Introduction of voluntary arrangement mechanism by virtue of section 2A to 2Q. Minimum debt threshold for creditors petition raised to 50,000 ringgits. Introduction of automatic discharge after 3 years. New DGI certificate of discharge for small bankruptcies. Enhanced protection for social guarantors and new insolvency rules 2017 and voluntary arrangement rules 2017 introduced simultaneously, and it is regarded as the most significant overhaul of Malaysian bankruptcy law in decades. There were certain amendments in 2020 and 2023. By virtue of Amendment Act 2020, the minimum debt threshold for creditors petition was raised from 50,000 ringgits to 1 lakh ringgits. It is intended to prevent wave of bankruptcies post-COVID-19. Gave individuals opportunity to manage finances without immediate bankruptcy action. Government stated goal. The goal was to boost economic recovery and reduce bankruptcy numbers. It was passed by Diwan Rakyat in August 2020 by way of voice majority. There were certain amendments in 2023 which came into force on 6th of October 2023. So electronic service of notices via email is now permitted by virtue of section 130 and rule 281A IR 2017. Remote communication technology allowed for creditors meeting by virtue of rule 21A IR 2017. New provision on suspension of automatic discharge rule 200A and form 100A. First meeting of creditors under section 15 no longer mandatory because it is dispensable by DGI, and it aligns Malaysia with modern international insolvency best practices. Now, let us see some of the timelines of key amendments to Act 360. 1967, it was enacted as Bankruptcy Act 1967. In 1988, it was revised and renumbered as Act 360, effective 31st December 1988. In 1988, the debt threshold was raised and provisions were streamlined. In 2003, further amendments to bring Act in line with regional practices. In 2017, major overhaul was done. It was renamed and voluntary arrangement was introduced and automatic discharge, and 50,000 ringgits was the minimum threshold. In 2020, this threshold was raised to 1 lakh ringgits in response to COVID-19. In 2023, provisions regarding digital service, remote meetings, and suspension of automatic discharge were made. Now let us see some of the practical aspects for legal practitioners. So what are the key procedural and advisory considerations? Creditor's perspective. So this is a practical checklist from the creditor's perspective. So first of all, you have to verify that the debt is either 1 lakh ringgits or more and is a liquidated undisputed sum. You issue 7-day statutory demand to debtor before petitioning. For social guarantors, exhaust remedies against principal debtor first. File petition within 6 months of the act of bankruptcy, and this time limit is strict. Serve petition personally on the debtor and advertise in Gazette. File proof of debt with DGI promptly after bankruptcy order. Attend and vote at creditors meetings. Participate in DGI's decisions and monitor DGI's administration. Appeal DGI's decisions to court if needed. So this is a practical checklist from creditor's perspective. Let us see the rights and options which are available from debtor's perspective. First of all, try to explore voluntary arrangement before any bankruptcy order is made. There is a right to dispute petition. You file affidavit opposing bankruptcy order. Right to apply to annul the bankruptcy order if order was wrongly made. You cooperate fully with DGI to minimize duration of bankruptcy. Apply for early discharge via DGI certificate or court order. Automatic discharge available after 3 years of compliance with all obligations. You seek DGI's return permission before traveling outside Malaysia and never obtain credit in excess of 1000 ringgits or more without disclosing your bankruptcy status. Now, rule of court versus Director General of Insolvency. High Court. High Court, by virtue of Section 88, Part 5, it makes and annuls bankruptcy orders. It grants or refuses discharge. It hears appeals against DGI decisions. It orders public examination of bankrupt, approves composition and voluntary arrangement schemes. It controls DGI's exercise of discretionary powers and general supervision jurisdiction over all insolvency proceedings. Director General of Insolvency. Part 4. It administers all bankruptcy estates as statutory trustee. It collects, realizes, and distributes estate assets, investigates bankrupt's conduct, and reports to court. It issues certificate of discharge for eligible bankrupts. It manages bankruptcy estates account and insolvency assistance fund. It may allow the bankrupt to manage property if it is considered beneficial, and it is subject to court control at all times. Now, see the voluntary arrangement versus bankruptcy, a comparison. What is the trigger point? In case of voluntary arrangement, the trigger point is debtor initiates before bankruptcy. But in case of bankruptcy order, creditor or the debtor petitions court. Minimum debt, there is no statutory minimum requirement in case of voluntary arrangement, but in case of bankruptcy order, it is 1 lakh ringgits in case of creditor's petition. Control of assets in case of voluntary arrangement, debtor retains the control under supervision, and in case of bankruptcy order, DGI takes over all the property. In case of voluntary arrangement, there are no travel restrictions, but in case of bankruptcy order, it cannot leave Malaysia without DGI consent. Business activity, in case of voluntary arrangement, it is allowed to continue to trade, but in case of bankruptcy order, certain disabilities apply. It is binding on creditors. In case of voluntary arrangement, it is binding on creditors if approved by required majority, and in case of bankruptcy order, this is also binding on creditors if DGI distributes proportionally. Duration in case of voluntary arrangement is as agreed in the scheme, and in case of bankruptcy order, minimum 3 years, and automatic discharge applies after 3 years. Outcome in case of voluntary arrangement, debt stands restructured or compromised, but in case of bankruptcy order, discharge is made after compliance and surplus is returned to the bankrupt. Now, let us see certain critical timelines under the Act. 6 months. Creditors must file petition within 6 months of the Act of Bankruptcy. Bankrupt must file statement of affairs within 24 hours of bankruptcy order being served. Period for creditors to object to DGI certificate of discharge is 21 days. Period for automatic discharge under Section 33C is 3 years from the date of the bankruptcy order. Voluntary settlements within 2 years of the bankruptcy are void, and settlements void for 5 years if debtor was insolvent at the time. So these are some antecedent transactions, these 2 years and 5 years. Now, what is the key takeaways? What is the essence of Insolvency Act 1967 in brief? So Act 360 governs personal insolvency in Malaysia. Corporations are excluded and they are governed by Companies Act 2016. Voluntary arrangement is the preferred pre-bankruptcy remedy and it was introduced in 2017. Creditor's petition requires 1 lakh ringgits or more of debt. It was raised in 2020 from 50,000 ringgits. DGI is the central administrator who acts as trustee, investigator, and distributor. 3 discharge routes are there: court order, DGI certificate, and automatic in case of 3 years. Major 23 amendment modernizes the Act with digital service and remote meetings. Court retains overarching supervisory jurisdiction over all proceedings. Fraudulent conduct is a criminal offense. Liability survives discharge, and subsidiary legislation, Insolvency Rules 2017, governs all procedural details. These are the references. So this was a brief overview of the Insolvency Act of 1967. This is intended to be a very basic awareness video which will encourage you to explore more into the field. In case you want a video on a particular topic or you are looking for a particular material, you can leave a comment in the comments section. Thanks for watching this video. If you are liking our videos, you can subscribe to our channel also to get more updates on insolvency. Thank you so much.